argument would be whether conviction under 303 was justified because or it falls under the exception 4 of 300, thereby the punishment ought to be having in 302 part 2.
Is there any sudden quarrel?
Yes, sudden.
Who
Even
was
if the
testified?
prosecution evidence are taken in toto and belief, then also my humble submission or my prayer would be that because it's the entire story of the prosecution is that there was a sudden provocation between the deceased and the accused. So even if the prosecution evidence is taken in toto, then also it would fall under exception of.
You are for
I am for Nipam Fukan.
Nipam Petai. Yes, Provin Fukan Bira. Yes.
Yeah, I am agreeing.
What are the issue involved apart from dying declaration?
Dying declaration, whether it can be termed as dying declaration or
Okay.
not, that has to be looked
So
into.
called,
Yeah,
let
that
us
has
say
to be-
so called.
Yeah, so called, that
Ah.
has to be looked into. Otherwise, no eyewitnesses. And I will not argue for sudden provocation and all. But as far as this hearsay circumstances.
Because circumstantial evidence, if it is
Sufficient.
circumstantial evidence, then where is the question of sudden provocation?
uh,
There is doubt.
Sudden provocation, I will not argue.
Exception may not come.
If my alternate was that if the prosecution evidence are taken into or believed to be true also, then
Yes,
also 300 will not or conviction under 302. will not
yes,
be.
MS Bhuya, how do you propose to get the copy of the paper book?
I'll take a Xerox copy.
Or
from
should we order?
No,
And we'll order that they misplaced.
I can
I'll observe that it is misplaced in the office.
Might be
I
my
can.
or by us, maybe some.
To supply another copy, I have to observe that.
Lordship. I'll take a Xerox copy. I'll get a Xerox.
You'll
Any
get
day,
hold,
tomorrow, day
you
after.
get hold of his notings also.
Yes. Lordship. Tomorrow, day after, any day, my.
After, day after.
Day after.
If possible, we'll do.
Yes.
Okay, Mr. R. Sharma, learned amicus curiae for the appellant in 1.
Yes.
And Mr. A. Kolita, learned amicus curiae for the appellant in 2. Are present, first of MS Bhuya. B. Bhuya, learned senior counsel and additional public prosecutor appearing for the state, has submitted that you collected paper book earlier.
Sure, ma'am.
Perused. Date. Paper book. Paper book. Name of transfer. Official signature paper book is ready but for his study. Public prosecutor receive reasonably. This has been issued.
Next.
Paper book furnished. So I have submitted that the paper book furnished to the office of the public prosecutor has not been traceable, and as such has sought as and as such submitting as such MS Bhuiyan has sought for a paper book post office to furnish a copy of the paper book to MS Bhuiyan.
I'll get it, they'll take some time, my lord. Today only I'll get it xerox and
Okay,
Lordship, rather than the day after
Then-
tomorrow, can we, I'm sorry, the Lordship will finish.
and then he does in Matthew. And has the sought for listing of the appeals. Yes,
So rather than the day after tomorrow, can we have it on 29 Lordship? Tomorrow I have some medical these things and day after maybe it may extend Lordship. So 29 if it is not inconvenient.
then we'll not fix, many matters may be fixed, so then we'll be only next week,
Lordship,
after a week.
after a
We'll
week,
not post any date.
Oh.
And sought for listing of the appeals after a week posted. In view of the prayer summit, the prayer, in view of the region cited, the prayer is allowed, list the appeals after a week on a date to be fixed by the office.
obliged.
Item number 3, obliged.
May please, Your Lordship. Case of conviction, my lord, under 302. Prosecution case was of confession as well as circumstantial evidence, my lord. So far as the confession part, my lord, the learned court will, learned honorable session judge has held that it is not a valid confession because 164 has not been complied with. So the only part,
What is not complied with?
164 has not been,
Which part?
time to reconcile and that part has not been complied with.
Where is the observation? Of the land trial court?
23, my lord, paragraph 23, page 53.
Where is it? Exhibit 12?
right. Relation portion, please 95.
But the magistrate testified.
PW 14.
Who is exhibit 11?
Page 89, ma'am.
Why the trial court has observed in paragraph 53 that there is 45 minutes time reflection?
My lord.
Paragraph 53 or
50
page 53.
Page
Paragraph.
53, madam. Paragraph 53, Lordship is referring to page 53.
Fair.
Whether that reflection time is to be counted from the time when he was remanded to judicial custody, or whether this reflection time is to be counted from the point of time he was placed before the magistrate on the following day.
Reflection time will be, my lord, from the time when is produced before the magistrate. And another aspect of the matter, my lord, another aspect of the matter, he was not assured that he will not be sent to police custody. That assurance is not there. That if you make the confession,
Original sound.
and moreover, my lord, there is no appeal by the state against that finding.
Is it the reflection time? Surely that is before the magistrate chamber. Is this the law? The chamber time spent in the magistrate chamber outside the, out of the shadow of police is the reflection time.
Out of the shadow of the police, my lord, if he's brought from police custody,
No, this is judicial custody.
Lordships, I
Orders.
think Sankaria judgment, 1978.
Yes, tell me,
435.
tell me. Huh? Judicial custody. Huh? No, judicial custody. What? Just wondering why he is straight away
Lordship,
rejected.
para 39. May I read
Please.
para 39? It is true that interval between the preliminary examination of the appellant and the recording of his confessional statement was about 15 minutes, but there is no statutory provision in 164 CRPC or elsewhere or even an executive direction issued by the High Court that there should be an interval of 24 hours or more between the preliminary questioning of the accused and the recording of his confession. The condition precedent for recording a confession by the magistrate in the course of police investigation is provided in section 164(2) CRPC, which mandates the magistrate not to record any confession unless upon questioning the accused person making it has reason to believe that it is being made voluntarily. In the instant case, the magistrate fully complied with the condition. He has testified that before recording the confession, he had fully satisfied himself that the accused wanted to make the confession voluntarily. A large number of clear and pointed questions put to him, to the appellant for this purpose, and the answers given by the latter had been extracted in full earlier. Their perusal shows that the magistrate had cogent reasons to believe that the confession was being voluntarily made. Although the interval between the preliminary questioning of the appellant and his confession was about 15 minutes, the appellant had not less than 38 hours at his disposal, which, whilst he was in judicial custody free from fear or influence to the police, to think and decide whether or not to make a confession. As noticed already, the appellant was brought from Ganganagar to Rasing Nagar on June 12, 1974, because on that day, no magistrate competent to record a confession of the appellant was available at Ganganagar. The appellant was admitted to the judicial lockup Rasing Nagar under the orders of the magistrate about or after 4 p.m. on that day. Thereafter, the appellant continuously remained in a judicial lockup or judicial custody till his confession was recorded on June 12, 1974 from 8:45 a.m. onwards. The magistrate Shri Bansal was aware that the appellant was continuously in judicial custody since the evening of June 12 for about 38 or 40 hours preceding the confession. In Sarwan Singh vs. State of Punjab, this court had emphasized that before recording a confession, the magistrate should see that the mind of the accused person was completely free from any possible interference of the police. In that context, it was observed that the effective way of securing such freedom from fear to the accused person is to send him to jail custody and give him adequate time to consider whether he should make a confession at all. In this connection, it was suggested, speaking generally, it would be, we think, be reasonable to insist upon giving an accused person at least 24 hours to decide whether or not he should make a confession. The court was careful enough to preface this suggestion with the remark that it would naturally be difficult to lay down any hard and fast rule as to the time which should be allowed to an accused person in any given case. It will be seen that how much time for reflection should be allowed to an accused person before recording his confession is a question which depends on the circumstances of each case. So it has been diluted.
This 24 hours reflection time cannot be in the official chamber.
My lord.
Very common sense.
My
It
lord.
is very common sense.
Lordship.
It is from judicial custody.
Lordship.
This reflection time, at least 24 hours, is judicial custody. On 28/12/2015, the magistrate has passed an order. The accused is remanded to judicial custody at district jail till 11/1.
Lordship.
So he was in judicial custody when he was produced on the next day, 29/12/2015. That 24 hours at least reflection time is to be counted as regards the judicial custody.
Yes, next line is clear, my
And
lord.
as an abandoned precaution, reflection time is given in the chamber of the judicial magistrate or whoever is going to record the statement.
Right.
And it normally it is 3 hours.
Right.
We normally see it.
My lord. Next line, my lord. The object of giving such time for reflection to the accused is to ensure that he is completely free from police influence. If immediately before the recording of the confession, the accused was in judicial custody beyond the reach of the investigating police for some days, then such custody from his very nature may itself be a factor dispelling fear or influence of the police from the mind of the accused. In such a case, it may not be necessary to send back the accused person for any prolonged period to jail or judicial lockup. In the instant case, the accused was got admitted to the judicial lockup on June 12 for getting the confession recorded under Section 164 CRPC, and such admission was made under the orders of the magistrate who ultimately recorded his confession on June 14. I think under 281, lordship says the magistrate has come up before the court. I think it's covered, compliance has been made.
I'm not very sure the reasoning given by the learned trial court.
Page 53.
I saw to page 53. Paragraph 23. That he has referred to Sarwan Singh. See,
Yes.
the effective way of securing such freedom from fear to the accused person is to send him to jail custody and give him adequate time to consider whether he should make a confession at all. It would naturally be difficult to lay down any hard and fast rule as to the time which should be allowed to an accused person in any given case. However, speaking generally, it would, we think, be reasonable to insist upon giving an accused at least 24 hours to decide. This is complied with. The judgment he has referred.
Check.
Reflection time is not in the chamber. 45 minutes.
That is one aspect.
To
Another-
decide whether or not we should make a confession. He should make a, whether there may be reason to suspect that accused has been persuaded or coerced to make a confession even longer period may have be given to him before his statement is recorded than 24. Shows that he warned the accused that he was not police but magistrate, but that he was not bound to make confession. If he did so, it will be, it is the order. It is the order 13. Exhibit 13 is the order by which does not so. What is the exhibit 13? Exhibit 13.
Page 97.
On the basis of exhibit 13, he has discarded. Well, CABC. এটা যে না জয়রাম বলে রাস্তার মধ্যে বেঙ্গলোর মাঝে খোলা কে জয়রাম জয়রাম that one you give Joyram, right?
Under the
Non-compliance of 164.5.
my lord.
There it was discussed Joyram. Yate what you put? মোক মানে জাজমেন্টৰ ৰিফাৰো কৰিছিল। He discarded it because of Exhibit 13 order. নহয় জানো? সেইটো কাৰণেতো 164 টো এই কাৰণে বেলেগ কথা। But we may be in disagreement. As an appellate court. No, you may not approve this kind of. Any politically don't go about it. ঠিক আছে কনভিকশন হয়েছে চাবলে কিন্তু এনেকুৱা হ'ব যদি ডিসকার্ড কৰি থৈ দিয়ে এই চকুমুণ্ডা খুলিব থৈ কোনো Exhibit 13 যে page 97 তাতে কৰা নাই বুলিহে কৈছিল তেওঁ চাব লাগে এডিট হৈছে নাই in substance in letter ৰেকৰ্ড কৰোঁতে একিউজৰ লগত ইণ্টাৰেকশ্যন কৰিছে নাই তাতে তেওঁ গোটেইখিনি মেছেজ কনভে কৰিছে নাই এইটোহে চাব লাগে অৰ্ডাৰ চিটতো লিখিব নেকি কন্ডিশন প্রেসিডেন্ট নহয় ন Then they not taking signature that one which went against you.
Yes, my lord. That
Joya
section 20.
something. Joya. There all these Sarvant and
Yes, sir.
Agnu. Okay. Let us proceed.
Come to the FIR matter at page 4.
Yes.
Page 4. I have the honor to state that on 26/12/2015 at about 3 p.m. my villager, namely Narayan Sharma, 55 years, son of late so-and-so, has been murdered. It's come to know from the villagers that he has been murdered by Lakhan Goali using a Nagadao at so-and-so block 1. May I therefore request you to kindly register the case and take necessary action.
What time it was registered? 3 p.m. 52nd. Huh?
FIR is on 27th.
27.
Registered on 27th.
Twenty-six is the date of occurrence.
26 is the date of occurrence.
3 p.m. evening.
Page 9 is PW1, my lord. He is the complainant. He is also a Caesar witness. His evidence read with the Caesar, etc., my lord, holds the key, my lord. Page 9. I am the complainant of this case. I know the accused person present in the court. His name is so-and-so. He was living with his brother-in-law at so-and-so. This is so-and-so is his brother-in-law. The accused was living together with his brother-in-law. On the day of occurrence, accused so-and-so and deceased so-and-so were present at home together. Wife of Narayan Sharma went to Nepal at that time. Narayan Sharma is no more now. The occurrence took place on 26/12. I was present at home on day of occurrence. I am Gaonpura, Borlengri Gaon. About 3 a.m. AM, my lord. It should up to have been PM.
Hmm.
Babulal Thapa, neighbor of Narayan Sharma, informed me over phone that Narayan Sharma has been murdered by someone.
It is perhaps PM.
It should be PM. ma'am.
Hmm.
Lordship will note, murdered by someone, and dead body of Narayan Sharma was lying in a cowshed. I went to Narayan Sharma's house. I had seen the bloodstained dead body of Narayan Sharma lying throat cut in cowshed. The villagers also gathered at the PO. The accused was not present at the PO. I informed Kotkoti police over phone about the incident. Police came to the PO. I was present at the PO at that time. Kithon and village committee members were present at the PO.
1 minute,
My lord?
1 minute. One minute. Yes.
So and so were present at the PO. Police has inspected the dead body of Narayan Sharma. Police recovered a bloodstained Nagadao besides the dead body of Narayan Sharma. Police seized the Nagadao. Police inquired witness at the PO. Exhibit 1 is the scissor list and Exhibit 1 is my signature. Material Exhibit 1 is the seized Nagadao. Exhibit 2 is the another scissor list and Exhibit 2-1 is my signature. Material Exhibit 2 is one sky blue color half pant. Police also sees black color half pant and blue color t-shirt. Exhibit 3 is the another scissor list and Exhibit 3-1 is my signature. Material Exhibit 3 is one black color half pant, one blue color t-shirt and from the dead body of Narayan Sharma in our presence. So Lordship will kindly note this is very important. PW1 says all the scissors were made on 26/12/2015.
Where he does he say?
On 26/12, my lord. He's saying it is seized on that day. If we read further, we will come to know, my lord. If we read further, then police prepared in.
Where is Exhibit 1?
My lord,
Where is Exhibit 1?
Exhibit 1 is at 62 page.
Hmm?
Page 62. Since Lordship is looking at page 62, Lordship will kindly make a note, my lord. It is MR number 139 of 2015 at the top. Date and time of seizure is 26/12/2015.
Exhibit
1,
MR number
139, madam, at the top.
yes. Page 62. Yes.
Now exhibit 2 at page 64,
MR number
140. And the date of seizure is 27/12.
what is the name of the disease?
Narayan, madam. Narayan Sharma.
Is it another seizure list? And okay. Yes.
Then lordship
Yes.
turns to page 66. This is exhibit 3.
Exhibit 2 is who neither has been Joyram. Why does it? No, no, it's not. No, তাতে মোৰ refer কৰা আছে।
Exhibit 2 is the half pant, madam. Sky blue color half pant with blood stains. That is exhibit 2.
Yes.
Then lordship turns to page 66. It is MR number 141. This is a black half pant and black t-shirt seized on 26/12. What I am on, my lord? The things seized on 26/12 is marked as exhibit 1 and exhibit 3. And the thing shown to have been seized on 27/12, that is the next day, that is marked as exhibit 2. And even the serial numbers. Exhibit 1, MR number 139 is dated 26/12. 140 is dated 27/12 and 141 is again dated 27/12. Sorry, 26/12. And PW1 says in seriatim how things were seized. Now, if we read PW1 further, my lord, may I read, my lord?
সিন করেছে 130 তারপর এখানে চিন করেছে রঙাকে লিখবে হ্যাঁ প্লেসের সিন করেছে এখানে অর্ডার অর্ডার এখন সিন করেছে পরিবেশন করেছেন সেটা হলো আমি জানি এটি জয়রাম তো আছে জয়রাম তো ইয়াতে কোড করা আছে কোনটো কংগ্রেসের ও নহয় নহয় এই জয়রাম এইটো নহয় জয়রামটো কোড করা আছে জয়রাম নে জয় I don't know.
Last week's matter.
Yes, last week only.
Yes,
Last week only.
I don't recall so many.
I cannot recollect.
The one I have given that is not.
Caesar to our Draconagot. Yes, Mr. Decker, do you think that this argument really have substance? When we'll consider it? This MR number.
Number
It
one.
really has substance? then-
I think so.
Okay.
I'll satisfy. that.
Okay,
Not just the MR number that read with the evidence of PW1.
yes.
May I read further, madam?
Have you
Full-
consulted the case there in other materials?
Not the
Original.
I have seen these MR numbers. I have checked records.
Yes.
We read further, my lord. Then police have taken the dead body from the PO. Villagers suspected to Lakhan Gayali because he was not present. Villagers searched Lakhan Gayali, but he was not found. At that time, I was undergoing treatment and hence I went home. This is important, my lord. On 27/12/2015, at about 7-8 AM, some villagers told me that Lakhan had been caught by villagers and they told me to inform the police about the matter. Accordingly, I informed police about the matter. Police came and arrested Lakhan Gayali. I was present at home on that day. I submitted a written azahar at my home as Gambura of the village. Exhibit 4 is my Azhar, Exhibit 4-1 is my signature. Lakhan confessed before the police that he had committed the murder, so and so. I do not know the reason for killing. So on 27, my lord, he did not go to the place of occurrence. So if the half pant, which has been linked to the murder, my lord, has been seized on 27/12, my lord, how he became the seizure witness, because he has not been in the place of occurrence on 27/12. In cross, he says that he has not seen. Now, while we are at the confession, my lord, I mean the seizure, my lord, lordship will kindly turn to page 28 and 29, my lord. It is the other seizure witness, PW 12.
Let us see your cross-examination of PW1 first.
PW1, my lord, Lakhan Goyali has been living together with his brother-in-law since 6 months before the occurrence took place. Babulal Thapa, the neighbor of Narayan Sharma, informed me about the incident. I have not seen the occurrence.
Okay.
Now, PW 12,
12,
if we read, my lord. I know the informant and knew the deceased. I do not know the accused. The incident took place in 2015. In the afternoon on the day of occurrence, I heard from the villagers that someone had killed Narayan Sharma. After getting the information, I went to the house of the deceased to see him. I saw him lying dead on the ground in the cowshed. At that time, police arrived at the place of occurrence. Police seized the Nagada from the place of occurrence, and I put my signature in the seizure list as a witness. Exhibit 1 is the seizure list, 1, 2 is my signature. Police seized a blood-stained sky blue half pen, and I put my signature in the seizure list as a witness. Exhibit 2 is the seizure list, and the exhibit 2 is my signature. Police also seized a black half pant and black t-shirt, both stained with blood, from the place of occurrence, and I put my signature as a witness in the seizure list. So and so is my signature therein. He also says, my lord, the seizures were made on that day. He does not say that these two were seized on 26/12. On 26, this was seized from his body. I was called on the next day also, my lord. And there is no explanation absolutely, my lord, why seizures made on 26/12 will be marked as exhibits 1 and 3. And he says, in the cross, he says, I came to know about the incident from others. I put my signature in the seizure list at the place of occurrence. The rest of the witnesses, my lord, have only narrated what they have seen after coming to the place of occurrence. Some discrepancies here and there, my lord, but not material as to what is seen. Some exaggerations are always there, my lord.
Seizure list is down. 1, 2, police seizure. So far, exhibit seizure list 2 is concerned. There is nothing that it was seized at a place of occurrence. Yes.
No, from the IO will come.
From the place, police also seized a black half pant and a black t-shirt, both stained with blood, from the place of occurrence. He has specifically said about seizure list 3.
3.
But he has not said anything where the half pen was seized.
In the cross, my lord, he says, I have signed it at the place of occurrence.
No, this is not a defense, mister.
No, I'm not saying that.
Specific, there has to be specific defense. It has not come out anything.
No, if your
From
lordship,
your
no,
defense,
if your lordship reads in seriatim how he narrates, Nagada is seized, blue half pen
we
is
have to
seized.
see, it's not seriatim, we have to see as a whole.
Yes, yes, if we see as a whole, my lord.
Whether it has a ring of truth or not.
Yeah, exactly.
Right.
Right.
Now, what defense you have taken here
I was not there.
regarding
not seized.
exhibit 2?
Look.
Seizure list 2.
So, the PW1 says that on 27/12, he did not even go to the place of occurrence. How he could have been a Caesar witness on 27/12? He says, I was at home. I was not well. I was under treatment.
But is there anything that the exhibit two,
My lord.
that the blue half pen which was wearing by the accused was seized from the place of occurrence because he was.
have to read the IO, man. My lord, we have to read the IO's evidence. It will come from the IO's evidence, PW 13. Let us read the IO's evidence. Man. Page 30. Married. On 27/12/2015, I was officiating as attached officer at so-and-so PS. That day, a person named Khemraj Upadhyay by name lodged an FIR with the PS informing that a person so-and-so by the name had killed Narayan Sharma, a fellow villager of the informant, by hacking him with a Naga dao. Shyamanta Sharma, the OC of the PS, received the Ejahar and registered Kotkoti PS case number 133 under 302 on the same day and entrusted me to with the investigation. Exhibit 4 is the Ejahar. Exhibit 4 is the signature of Shyamanta Sharma, the OC so-and-so. At about 4:10 p.m. on the previous day, that is on 26/12, Khemraj Upadhyay had given information about the murder over phone, and accordingly, GD entry number 693 was made at Kotkoti in this regard. The OC entrusted me with the investigation of that case that day itself. I went to the place of occurrence on 26/12, just after the GD entry had been made. At about 4:30 p.m. that day itself, I moved out to the place of occurrence with staff. The executive magistrate of Bokajan, Eric so-and-so, accompanied me to the place of occurrence. On arrival at the place of occurrence, I saw deceased Narayan Sharma lying dead on the floor in cowshed. I found 5-6 inches long cut mark in the front part of his neck, which seemed to have been caused by hacking with a dao, and saw the deceased lying in a pool of blood. I saw a bloodstained Naga dao about 8 to 10 feet away from the place where the dead body was lying. I prepared a sketch map of the occurrence. Exhibit 9 is the sketch map. 9-1 is my signature. Thereafter, I seized the 1 foot 11 inch long Naga dao fitted with bamboo handle in presence of witnesses. Exhibit 1, so-and-so, so-and-so. Thereafter, I seized the bloodstained black half pen and a black t-shirt worn by the deceased in presence of the witnesses. Exhibit 3 is the Caesar list. So-and-so is the signature. Thereafter, the executive magistrate comes so-and-so held inquest on the body in presence of the witnesses. Exhibit 6 is the inquest report. And exhibit 6-2 is the signature of so-and-so. The executive magistrate comes so-and-so. Thereafter, upon recording the statements of the witnesses at the place of occurrence, I came to know that Lakhan Gali.
1 minute. Were the inquest?
73.
Yes.
I was reading the IO memo.
You read from exhibit 1 is the seizure list. And exhibit 1-3 is my signature here.
Yes. Thereafter, so-and-so, the executive magistrate comes so-and-so, held inquest in the presence of the witnesses. Exhibit 6 is the inquest report, so-and-so, which I have recognized.
Where you read?
Page 32.
Oh, you have gone to page 32. Okay.
I'm skipping the marking of the exhibits part, my lord. I have recognized. Thereafter, upon recording the statements of the witnesses at the place of occurrence, I came to know that Lakhan Gayali, the elder brother of the wife of the deceased, had committed the murder. Prior to this incident, the accused stayed at the house of the deceased person. Thereafter, we searched the house, but he was able to flee from the place of occurrence. That day itself, I sent the dead body to Diffu Hospital for post-mortem examination. On the following day, that is on 27/12, the informant of this case informed over phone that they have found the deceased and deceased should have been accused and detained him. Getting the information, we immediately rushed to the place of occurrence and found the accused detained by the villagers at village so-and-so. At the place of occurrence itself, the accused confessed before the public that he had killed the deceased. At that time, I saw the sky blue half pant which he was wearing stained with blood, and suspecting that it might be the blood of the deceased, I seized the half pant of the accused in presence of the witnesses. So seizure is at the place of occurrence. Exhibit 2 is the seizure list and Exhibit 2-3 is my signature diary. At 2 p.m. that day, the accused was brought to the PS. Thereafter, on 28/12, after medical examination of the accused, he was sent to judicial custody and made a prayer to the Honorable Court for recording his confessional statement. And accordingly, the Honorable Court recorded his confession.
28/12/2015 perhaps.
It is 15, madam, not 18.
Hmm.
On 29/12, I sent a bloodstained Nagada on half pant one, a half pant stained with blood of the deceased, and the bloodstained blue half pant of the deceased to Forensic Science Laboratory. I collected the postmortem examination on so-and-so and received the reports of the dow and clothes on so-and-so. Thereafter, having found sufficient materials of involvement of the accused in this killing, on 28/12, I submitted the charge sheet number so-and-so against it for committing an offense under 302. Exhibit 10 is the charge sheet and 10(1) is my signature. Cross-examination. The place of occurrence is at a distance of 8 kilometers from the police station. I arrived at the place of occurrence at 4:55 p.m. on 26/12. When we arrived at the place of occurrence, many villagers assembled there. I sent the seized dow to the laboratory for examination of blood sample, but I did not get the fingerprints examined. After getting information of the accused being apprehended by villagers, I again went to the place of occurrence, and at that time, a lot of villagers were present there. The villagers apprehended the accused at a short distance from the place of occurrence, where when we arrested the accused, we were not aware that he was in an inebriated condition. And if we come to the 313 also, my lord, at page 39. Question number 20 and 21. PW 14 stated that
All are false.
all are false. PW
Okay.
explanation is in 20 and 21.
No, 1, 2, 3, all are false.
Page 39.
All false. All false. Page 36. Even if you have denied that you used to reside with the disease in the same house. In your 313, is it not? Because PWs are categorical in their testimonies that you used to reside
Yes.
with your this deceased in the same house for a period of time. Now, question number 1, this is also false.
PW1 stated that the occurrence took place on 26/12, and at that time you were living together with the deceased in his house, and wife of the deceased was in Nepal.
Even this is false.
This is false.
Not replying is one thing. No comment. But this is false, and false explanation.
Well, at that time you were living together. Maybe it could be.
Well,
at that-
everybody
at
is
that
saying,
moment of time, it was
everybody
not
is
there.
saying, Mr. Dekka, that
I followed, Manu. I followed what his authorship is.
now the question is that your explanation as a whole is to take into account. Now we'll go to that. Everything is false.
Everything is. The rest are all the incriminating materials which he has been confronted with.
Oh, he has said. I was staying.
Later on, he says, my lord. In 21, he says. 20, he says, I did not confess that I murdered the deceased. My signatures were obtained in confessional statement and marked as so-and-so without explaining its contents to me. 21, he says, I was staying in the house of deceased so-and-so together. And on the day of occurrence at 9:30 a.m., I went out from the house for going to Dimapur. On the following night of the day of occurrence, I was in Dimapur in the house of my friend so-and-so. In the morning of the following day, when I was coming from Dimapur back on the way, I was apprehended and tied by the villagers.
So your trend of cross-examination did not reflect that you were taking a plea of alibi.
Yes. The issue
No,
is, my lord.
I'm-
Yes.
What is there is
Yes,
there.
what is there is there, my lord.
The trend of cross-examination
Yes.
or any suggestion was not to the effect that
Yes.
you were somewhere. Now, at the stage of 313, it appears that you are taking a plea of alibi.
Yes.
How do you substantiate it?
My lord, the issue is the first and foremost, my lord, the chain of events has to be complete, my lord. The only evidence linking me to the murder is the bloodstained half pant, nothing else, my lord. Admittedly, I am not there.
So,
Admittedly, I am not there, my lord. Now, whether that link, the evidence has been linked, my lord, whether the chain is complete, that is the only thing that has to be seen, my lord.
what is your
Confession,
explanation?
my lord,
What is your explanation?
explanation regarding
What is your explanation then? Why it has matched?
what has matched, my lord?
The
Only the blood group has matched.
blood group
Yes,
in your half pants
yes.
of the blood stains of your half pants.
No, my case is it is
1
not
minute.
seized, my lord.
1 minute.
Yes,
Okay, you carry on.
my lord.
You carry on, please.
Page 78, my lord. This is the forensic report, my lord. It says it gave positive test for human blood group of A. No evidence, my lord, whether what was the blood group of the deceased or of the accused of the appellant, my lord. There is no blood group matching. And regarding the seizure, my lord, I am saying that it is from the evidence, it is clear that it was not seized from my body, my lord. It was seized on 26/12 itself. PW1 is clear. PW1 has not been declared to be hostile. And if we read PW1 and PW12 together, it is clear, my lord. It was seized on 26/12, shown to have been seized on 27/12. And the marking of the MR numbers, the maintaining of the serial, my lord, everything has to be some seriality has to be maintained, my lord. Why will I skip exhibit 2, my lord, while I am seizing the materials? Now, my lord, I'll rely on PW6 also. Man, PW6, my lord, page 16. Kaushik has got it. I know the informant and the accused. I knew the deceased. The incident took place in 2015. Around 4:15 p.m. while returning from my workplace, I saw a large number of people of the village at the house of Narayan Sharma, and when I asked them, they replied that someone had killed Narayan Sharma in the cowshed. I saw the deceased lying in the ground in the cowshed and also saw blood oozing out from the whole body of the deceased. Around that time, the accused used to stay at the house of the deceased, but as the accused was not seen at the place of occurrence, after the incident, the villagers expressed their suspicion that the accused had killed the deceased. And then they started searching for him. In course of the search made by the villagers around 7 a.m. on the following morning, the villagers saw the accused while he was consuming alcohol in the house of the person Uttam Rai by name, and after apprehending him, the villagers brought him to the house of the deceased, where the accused confessed before me that the other villagers present there at the time that he had killed the deceased. Thereafter, the headman of the village informed the police, and whereupon the police arrested the accused. Now the cross-examination. I was not present at the place of occurrence at the time of occurrence. When I went to the place of occurrence, the accused was present there. Though I heard that the accused stayed at the house of the deceased, I did not witness it. I did not hear about any quarrel between the deceased and the accused. At that time of apprehending the accused by the villagers at the house of Uttam Rai, I did not see blood on his person. I did not witness the accused killing the deceased.
For the accused. Okay. On each person, right? Sequence, you need to figure out the The place of occurrence. Of open for seizure. Then is the school disappear, data school, and can't research. Then to a next. It is 7. Read a seizure. This man is a seizure witness.
Which man, my lord?
Yes, you have read
No.
PW6,
PW6 is not.
not a seizure witness.
Caesar witness is PW1 and 12.
One and 12.
12.
What is his name?
My lord, the name of 12. One is the informant himself, Khemraj Upadhyay. 12 is
Ithang.
E. Kithang. And 26 and 27 may also be seen. Page 26, that is the PW11. What were sent for forensic, my lord? Description. One bamboo handle Nagadao contains chain so and so. Total length, I think it should be 58 centimeter, not 158. Because if it is 158, it does not match, my lord. I've checked up. It should be 58. Page 78. It is 58, my lord, if we compare with page 78.
Okay.
Total length so and so, so and so. The result of the examination is exhibit so and so, so and so, so and so gave positive test for human blood of group A. Does not say whether it is the same blood, same person. In my respectful submission, my lord, the chain is not complete. I will not repeat myself, my lord. Seizure is not proper. Everything was seized on 26/12. PW1 is clear on that. Because on 27, he says, I have not gone anywhere out of the house. I have given my FIR, even the FIR has been given from my house. So the only evidence linking me to the murder is that half pen. That also, my lord, the blood, it does not say it is of the same person. If the chain is not complete, my lord, it has not been proved beyond reasonable doubt.
Whether anything
And on the
under 106. Okay, anything required from your side under 106?
106, my lord. There is a finding of the learned session judge regarding 106. But I think, my lord, that my respectful submission, that explanation that I am not there.
That will not suffice. See, there are two things. If it is shifted, and if you take a plea of alibi, this has to be established as a fact. Not taking a plea, it amounts to falsity.
Not giving an explanation.
Yes, not giving an explanation or a false explanation, it becomes an additional link. But whether before that to bring in to operation 106, what can be established by the prosecution? So what else can be established by the prosecution? What else? Apart from this, what else can be established by the
Other
prosecution?
materials, my lord.
This is not a doctrine that everything, every link is to be established. Now there is new concept of prima facie case. Only 106 will not do. Now there is a case. Now new rule as principle has evolved, very recent, that prima facie case. Not only 106, prima facie case. What is possible to be proved in a case of circumstantial evidence, if the prosecution has done it and made a prima facie case, then things will get shifted.
For purpose of 106.
106 also, prima facie case. Now this new principle has, I have seen.
Ma'am.
Anis to our Bhagita, Balbir, Sorbir, Tintaman. Yes, Anis, Balbir and all this.
After Anis, another new judgment has arrived.
Wazir or what?
Yes.
Then
Everyone
Balbir,
has-
Balbir is also there. Question is not only 106.
Concept of.
It is a prima facie case.
difficult.
Because what is possible for the prosecution has to be proved. And suppose, and now your trend of examination, we have to see that many of the prosecution witnesses had said you used to reside together.
Yes.
Though it is not a case of last seen together in the stricto sensu, but at the same time, same thing in Sanjay Thakran says that maybe a longer one, but still,
Coupled with the fact that they were living in the same house.
yes, coupled with the fact, and at that time, wife was not there.
Yes.
He was alone, you were alone. Meaning there were two
2%.
persons. So in that case, and it is not possible if the persons are inside the house.
That I'm
That
okay with.
theory, it is that stricto sensu last seen together. Time gap may be longer also.
Yes. No, but the chain would have been complete.
Right, it is a case of circumstantial
Yes.
evidence.
So,
So what else I am asking you?
may I, ma'am?
I have got the satisfaction regarding marking of
Yes.
that.
My lord, if
I have asked my esteemed sister also, what is how this is to be marked, when marked, because we are not.
yes.
So we have checked the case there to inspire whether it inspires confidence or not, but the sequence of events, statements are recorded, 161, just for a purpose to inspire confidence. Mere marking that is marked not serially, that may not be a case which has
Solely
ended
may
the
not
case.
be. Solely may not be.
That is not a case at all.
My lord, but
Because you have argued it, so that is why I have to write it.
no. But why I have
That is why Mr. Dekar, after looking at it, I have posed the question that are you seriously arguing the case on this mark?
I would not have.
139, 140 and 141.
I would not.
I
have.
have to
Yes, yes, Lordship will have to
I
answer.
have to spend time,
Yes, yes.
right?
No, no,
That
why-
is why I have said.
My lord, why I have argued is because of PW1, my lord, not otherwise.
That will be dealt with.
Only because of PW1 and my lord, that query lordship is what could have been proved, my lord.
Yes, yes.
Fingerprints, blood, and if whatever the prosecution has placed, if this chain is complete, then my lord, I think 106 would have come. And even without 106, my lord, chain is more or less complete. Because if the blood of the deceased is found on my body and I cannot explain and I am caught on the next day, then my lord, the chain would be complete. But here in my respectful
But
submission,
at
whether
least you owed an explanation why, because since I have seen that this dhow was seized near the dead body.
yes,
It contained blood stains. Then next one, this wearing apparels of the deceased was also seized at the place of occurrence, cow said. And there is a statement of executive magistrate also, just to inspire confidence.
yes.
Who did the inquest. Then you were apprehended at someplace else
Yes.
in the next morning,
Yes.
notwithstanding the evidence of PW1.
No, PW1 also says I was brought on the next day.
Huh. Then PW6, he arrived a little later on, but you were apprehended at 6 a.m. next day.
Yes.
So why the blood stains, the blood group of the blood stains in your wearing apparel matches with the other two?
Provided, my lord, provided with a caveat, my lord, that was seized from me.
Yes.
Provided that is seized from me. That is the whole crux. If it is seized, if it is established that it is seized from me and I do not offer any explanation, then presumption may come, my lord. The burden might have shifted. But first, it is the burden of the prosecution to prove that it was seized from me, my lord. Reading PW1, the IO and PW12, my lord, in my respectful submission, my lord, that does not inspire confidence, along with the seriatim maintained. PW6 is not a seizure witness, no?
Three. Okay, we'll come back after 5, 10 minutes.
My lord.
Latest one is Manharan Rajware versus State of Chhattisgarh. Signature of the person making confession is mandatory.
On one, on 2, 3 points, we need assistance in the sense that firstly, trial court discarded 164. And despite discarding 164, trial court has held that prosecution has proved its case. So purpose of the prosecution is served, say. So since conviction, that trial has resulted into conviction, so there is appears to be no need for the prosecution to prefer an appeal. You have, since you have argued that point. Now, whether as an appellate court, while dealing with an appeal, which is considered to be continuation of the original trial, we can reappreciate each evidence. Now, while doing so, if we find that on a particular point, when a trial court has gone, support, wrong, whether we, after disagreeing with that finding, can record our own finding on that particular point. Have you understood my question? Query. Since you have argued that point. And suppose after disagreeing with the finding of the trial court, because the judgment which he has, the point on which he has done it, that appears to be primacy, not on correct perspective. To my tentative view, our tentative view. If we can disagree and thereafter record our own finding, then it becomes, it would add 2 more circumstances. Right. Have you understood? One is judicial confession, which can add weight to the case of the prosecution. After acceptability, that proper procedure was followed, that the question that you have said may be a mere irregularity. That after, even if you do not make any confessional statement, or you will make a confessional statement, you will not be sent to police custody. Only that. Otherwise, I have seen questions were asked and answers were recorded. Right? If we find that after disagreement that we can accept the judicial statement, then since it is a case of circumstantial evidence, that judicial confession recorded under 164 add weight to the prosecution case.
Circumstances.
Right? Plus, if we read the judicial statement, then there you will get the motive also. Right? Then these two would be adding weight to the
Prosecution.
right. So this is the point. Just I am looking for. Have you got? Otherwise, Mr. Deka has covered all the point. Now you'll definitely argue. But this is, please keep this
My lord.
2 things in mind.
Then before my learned friend starts,
Huh.
can this be taken up on either day after tomorrow or next
Okay,
week?
we'll do that, but let us
Oh.
have her view also. If she conclusively comes with the answer,
Then, my lord,
Let-
I'd like to place a judgment, my lord.
okay, we'll be given the opportunity. Let
Let-
us hear MS Bhuya. And please keep
My
these
Lordship,
2 things in mind.
my lord. First, I'll answer your lordship's query
Confessional
as regards confessional statement, which was according to my submission is it is recorded as per law, my lord, as per law laid down and the rules laid down by Honorable
Still
Guwahati
that
High Court.
point
That's still,
that
that whether
will
it's
not be
a,
sent to police custody.
yes, my
That
lord,
is.
that is not there,
Uh-huh.
whether it's fatal to the prosecution case. Your lordship, the 164 statement.
So far the
for-
violation of Dhananjay Reddy is concerned, here it is made.
Made,
I have
my
seen
lord,
it.
my lord.
I have myself seen
Lordship.
it.
So 164 statement is a strong lordship's corroborative piece of evidence. Your lordship, even if your lordship relies on 164 statement, there has to be other factors, other circumstances, my lord, in the case of circumstantial evidence. According to me, your lordship, in the state, we have a strong circumstance, which certain circumstances which goes against a accused person. First, accused and a deceased is to live in a same house. Lordship, no explanation from his side. And PWs have categorically stated in their evidence, my lord, they used to live together in one house, my lord.
And wife of the accused and other family members were not there.
Not there.
That is
They
also
were
the
in Nepal,
deposition of
yes,
few of the witnesses, but there was no cross-examination on that
To
point.
that effect. Then another is an extrajudicial confession made before PW5 and PW6. And PW7 has also stated that confession was made before, that would be extrajudicial confession, which is made before the public, and he was present there, your lordship.
PW?
PW7,
Hmm.
that extrajudicial confession made before the public, and he was very much present there at the place when the extrajudicial confession was made. Then, your lordship, strong circumstance, the wearing apparel of the deceased, wearing apparel of the accused person, and the weapon of assault. Bloodstains have been found, which was, although it was not proved whether it belonged to the deceased, lordship, it was of the same group. Then, I have seen the Trivandrum statement, question number 18. It was put to the accused, my lord.
18.
Yes. He further stated that he sees one bloodstained Nagada, bloodstained black color half pant and black color t-shirt, that he got the dead body of the deceased inquested, and he recorded statement of the witnesses that on 27/12/2015 villagers informed him that you were apprehended, and coming to PO, he found you wearing a half pant containing bloodstain, and thereafter he sees the same half pant exhibit. What is your saying? He said no, my lord. Because he didn't deny that it did not belong to him, my lord. The bloodstain half pen which was worn by him. And your lordship, when section 106 attracts your lordship, the very presence of the accused person in the place of occurrence. You should have one explanation to that effect, because other circumstances, I think prosecution could prove, along with the presence that he was very much present in the place of occurrence.
This is town area or rural area?
8 to 10 kilometers, I think, from the PS itself. Eight kilometers from the police station.
And there's no cross-examination to the effect, the extrajudicial confession which was made before the persons, the inimical manner. There's no cross-examination to that effect. So these circumstances, I think chain is, I think, complete, your lordship, that the accused person is the perpetrator of crime. And your lordship may reappreciate the evidence and the judgment passed by.
Some, yes.
Yes, the learned trial court. When other circumstances, the prosecution has got weak kind of evidences, but in the present case, lordship, my respectful submission is that the strong circumstances which is in favor of the prosecution, my lord. So in that event of the matter, even if your lordship do not appreciate that the learned trial court rejected the 164 statement, other circumstances will still stand in order to uphold the conviction.
But regarding that point, disagreement and
Yes, my lord. I'll try to
having
find
a
out,
fresh
my lord,
look
lordship,
on the
lordship. I have
materials
understood.
on record
Yes, my
and to reach,
I think the lordship can,
yes, but
appellate court can, I'll try to find out.
can,
judgment to that effect.
has ample power still.
Lordship,
হয় নহয় মোৰ যে হেৰিটো মোৰ নোটখনৰ নোটৰ যে এইটো চাওঁ, correspondence. কিবা যে এলিবাই এটা যে আছিল এলিবাই যে তোৰ লিখা আছিল যে এলিবাই What about PW1? That learned amicus has urged that PW1 was at home,
lordship,
but yet he had signed the seizure list exhibit 2.
lordship, his evidence, my lord. Page 9. I am the complainant of this case. I know the accused person present in the court. His name is Lakhan Gayali. He was living with his brother-in-law at Borlangri Gao. This is Narayan Sharma, is his brother-in-law. The accused was living together with his brother-in-law. On the day of occurrence, accused Lakhan and deceased Narayan Sharma were present at home together. Wife of Narayan Sharma went to Nepal at the time. Narayan Sharma is no more now. The occurrence took place on 26/12. I was present at home on the day of occurrence. I am Gaubura of Borlangri Gao. About 3 a.m., Babulal Thapa, neighbor of Narayan, informed me over phone that Narayan Sharma had been murdered by someone and dead body of Narayan Sharma was lying in the cow shed. I went to Narayan Sharma's house. I had seen the bloodstained dead body of Narayan Sharma lying throat cut in cow shed. The villagers also gathered at the PO. The accused was not present at the PO. I informed Kotkoti police over phone about the incident. Police came to the PO. I was present at the PO at the time. Eton and village committee members were present at the PO. Police has inspected the dead body of Narayan. Police recovered bloodstained Nagada. Beside his dead body of Narayan Sharma, police seized the Nagada. Police enquired witness number Caesar list. Exhibit 1 is the signature. So he was very much there, the place of occurrence. Immediately when he was
No, he was
informed,
not at home. He somewhere said he was at home. Let us find out once again.
no, on the day of occurrence, he was at home. He said,
Hmm?
I was present at home on the day of occurrence. Lordship 1, 2, 3, 4, 5, 6 line, page 9.
Occurrence took place on so and so. I was present
Yes,
at home.
yes,
I am Gambura.
yes,
At
Then
3
there
a.m.
are-
Babulal Thapa
yes,
informed me over phone.
yes.
Someone murdered. Dead body was lying. I went to so and so. I saw bloodstained body lying throat. Also gathered at the PO. Accused was not present. I informed Kotkoti police over phone.
Yes,
Police came to the PO. I was present at the PO that time. Eton and village community members were present. Police had inspected the dead body of Narayan Swami. Bloodstained dog seized.
So he was present, my lord.
And this is exhibit 2 is another seizure list. And 2-1 is my signature. Material exhibit 2 is the so and so. Police also seized material exhibit 3.
So he
Seized
talks about
dead body
PW12
of in
also.
our presence.
Eton is
In our
PW12.
presence. Police prepare inquest. I have not signed. The police have taken the dead body. The villagers suspected. Villagers searched, but even at the time I was under, hence I went. The 7 another police secretary into the resident. It does not emerge specifically that he did not go to the place of occurrence.
Yes, my lord. Lordship, regarding the review, reappreciate the evidence. May I refer 2007 4 SSC 415? Chandrappa versus State of Karnataka.
Okay.
Mm-hmm. 2007 4 SCC 415. Then it's appeal against equity, appeal in case of equity. Let's say, let's.
Hmm.
Appellate court.
Yes, my lord. It is also well settled that the Court of Appeal has as wide power of appreciation of the evidence in an appeal against an order of acquittal as in the case of an appeal against an order of conviction, subject to the riders that the presumption of innocence with which the accused person starts in the trial court continues even up to the appellate stage, and the appellate court should attach due weight to the opinion of the
That is
court
regarding
as well as in
appeal against acquittal,
acquitted,
basically.
as well as
Right, that is okay,
That
but
is okay.
still, that is not,
in case
that
of
is
conviction
regarding
also.
presumption,
Yes, my lord.
double
It's a
presumption.
Presumption as against order of acquittal.
Because there the state is the appellant.
My lord,
That you are reading
My lord.
where the state is the appellant.
lordship,
Appeal against acquittal.
lordship. Here.
We are concerned with appeal against conviction. I think it will not serve the purpose.
Here, various observations are there,
I need specific one.
my lord.
Huh?
Itu kan, itu betul.
Hmm. Appeal against acquittal, state করেছে। state appeal against acquittal, state করেছে, state আমি জানি ওই সময় state हाँ।
See, principle.
हाँ। বলবি তো ডিরেকশন বলবি হ্যাঁ বলবি না আনিস আনিস কি ব্যাপার বলে হচ্ছে minimum 24 hours reflection time is okay at least, but I think that is made
Subsequent judgment, there is no flexible formula as such.
at least.
My
I
lord.
say.
Lordship may produce section 386 of the CRPC. 386B. Powers of the appellate court. In an appeal from a conviction, my lord, subsection 2, alter the finding, maintaining the sentence. Lordship will give me some time to address your lordships whether this alteration can be to the prejudice of the accused. Because in a civil appeal, my lord, normally under the CPC,
That is no.
the cross objection has to be filed.
That is why I have said that in an appeal against conviction, suppose trial court has recorded a finding on a particular point
In favor of the accused, my lord.
in favor of the accused against the prosecution,
Yes.
but the trial resulted into conviction
On some other issue.
on other points.
Yes.
And thereafter, so some purpose of conviction has been made for the prosecution. So whether they need to file appeal, may not be. But in an appeal against conviction by the convict, whether the points can be urged by the prosecution, that issue has been
Exactly.
wrongly decided by the trial court.
Can be.
So
Can we
the
explore-
appellate court has full power to reappreciate and decide on that point. That is a specific,
Yes.
We'll go.
We'll have to do
because
some.
conviction remains,
research.
conviction
Yes,
remains.
yes.
Whether it will be any prejudice to the accused.
Because when in a situation, it may so happen.
Civil
No, not on
jurisprudence is
civil.
different.
No, in a given situation, it may happen, my lord, that a prosecution relies on two grounds. One ground is rejected by the trial court, the other is accepted. Now, the appellate court is not willing to accept this ground on which the conviction was based. So on the other ground, can it be reversed to the prejudice of the accused?
In my view, it is permissible, but still,
Let us.
I am still of the view that it is, if the finding remains same, sorry, the
Sentence.
sentence remains the same. Conviction remains the same, then other points which was wrongly decided on facts and law by the learned trial court, the appellate court has full power to reappreciate. and record its own finding.
Finding.
This is my view, but subject to correction and confirmation. Or subject to modification. Both, all three, open. That is only the point. Because if that can be done, then that will give rise to two more additional circumstances, or maybe more, at least two,
Motive part.
that it might corroborate the other prosecution evidence which have been laid,
Yes.
right? Judicial confession is a
Confession.
strong
Strong
circumstance.
circumstance.
And also, in a case of circumstantial evidence, motive plays a role. Then that is clear from 164 statement. That motive. That is another issue, whether it was grave and sudden provocation.
Provocation.
But then we'll add weight to the prosecution. That is the precise point. Should I? This is the issue.
Good.
2 hour tentative view.
Let us burn some midnight oil, my lord.
Okay.
Lordship, I'll be relying on alibi point also.
Yes,
because-
you can alibi,
to
false
substantiate
explanation,
that-
no
yeah.
explanation, you can
Yes.
everything. Prima facie case, you can argue
From
anything.
that point, I'll rely on the judgment, my lord. That will be.
Prima facie case, we have seen recent trend. I have just seen at least 2, 3. By Honorable Justice Pardiwala, 3 judges.
So that will be binding on.
Prima facie case, just I can make one observation that, see the one line. Section 106 of the Evidence Act would apply to cases where the prosecution could be said to have succeeded in proving facts from which a reasonable inference can be drawn. It has been slightly diluted perhaps.
In 2021 also, there is a judgment, my lord.
But all these have been discussed. All. Very good. Okay. Had Mr. Ndeka learned amicus curiae for the appellant and Ms. B. Huya learned senior counsel and additional public prosecutor for the respondent state assisted by MS M. Chakraborty. Post learned counsel. As sought for by the learned counsel for the party, release the case on Thursday.
Day after tomorrow.
Otherwise, we'll
No,
forget.
no difference. Will it come as a parted matter, my lord?
No, we are here. There is no other bench.
Yes. Obliging.
Huh?
May I please, your lordship?
Yes.
Lordship, supplementary matter item 7, lordship.
Yes.
Lordship, supplementary matter item 7, lordship. I was a bit late because of the waterlogging and the rains, lordship. The 2 weeks has been fixed, lordship.
We
Waiting
passed the order already.
I was just
Waited.
just for dusty service. I may be allowed to take dusty service, lordship. That's my only submission.
You have brought the matter by order, then you were not present.
But lordship, I was still wearing the weight shoes, lordship. Heavy
Let
waterlogging.
it come. The 2 weeks.
My lord, in item,
Which item number 4?
my lord, in item number 5, my lord, I was just informed by one advocate, my lord, that the counsel for the appellant is absent, my lord. He's out of station.
We don't know. Let him, let the matter be called. There is no mention from the appellant side. If he does not appear, we'll replace. And who is for item number 4? You're there.
Appeal dismissed.
Item number 2, criminal appeal Z 30 of 21.
Thirty-six piece. Huh? Judgment and order of the learned trial court is satisfied and costs resultantly this criminal appeal succeeds.
Highly obliged lordship's doing. So in my humble submission, my lord, prosecution is not being able to weigh out the circumstances that narrated ultimately lead to the conviction, my lord, because deceased and the accused persons are two related brothers, my lord. They have spent night on the day of occurrence in the house of accused has spent night having dinner with him in the night in the house of deceased, my lord. And there are cut injuries in both the persons. Accused died because of that cut injuries, my lord, and as well as the deceased also. Accused having the cut injury, he was lying on blood pool, my lord, and he was hospitalized for 1 month, my lord. Thereafter, police has sent him to hospital, my lord, on the day of occurrence. When this information has been received by the police, they have gathered to the place of occurrence, as well as they found the accused deceased in another room. He is also having cut injury, and out of that cut injury, my lord, that person died in the spot also.
Okay, let us see the postmortem first.
Yes, my lord.
Fifty-four. 84 to 90.
54, that is in the judgment,
84.
84.
84, my lord. 84 to 90. my lord.
Many injuries,
Many injuries, my lord.
It's our.
apparently murder. Was done on 28th August, okay. That is the opinion.
Death due to hemorrhage, shock as a result of injuries sustained over the body. As described, all injuries were antemortem and caused by sharp cutting heavy weapon.
Homicidal in nature.
Homicide.
Homicidal damage.
Okay, where is the FIR?
Where is it? Page 4 of the paper book. ma'am. This is also an
So-
exhibit 5.
Incident occurred in the night intervening 19:08 and 28.
Midnight,
Hmm.
11 to 12 more or less, ma'am, all the prosecution officers. says. May I read, ma'am? Humble submission is that around 12 AM yesterday, that is on 19/8/18, when I heard someone running from the side of Sri Ravi Jajwar's house, I went to his house. Going there, I found Ravi Jajwar lying unconscious in a pool of blood at the courtyard of his house. Then I cast a glance at him hurriedly. I saw wound on his neck inflicted with sharp weapon. I learned that as both of them had been asleep together at night, a quarrel had taken place between them over some issues, and that following Following that quarrel, Sri Rabihud Jajwar had died in the house of sustaining grievous house after sustaining grievous injury inflicted with sharp weapon. I found Sri Rabihud Jajwar in a grievously injured state. I suspect that Sri Rabihud Jajwar had hacked Rabihud Jajwar to death with sharp weapon. Here is my lord, informant is not examined because in the meantime, he died, my lord,
Died.
died. Prosecution is having 14 witnesses along with IU and doctor, my lord.
So, accused is of Obihud,
Jajwar.
Obihud, and disease is Robihud. Okay. PW1,
PW 1 and 2 are the seizure witnesses, my lord. I know the informant Jarobian Jajwar, who is already dead. Accused Abhihud Jajwar is from my village. About 5-6 months back, the incident occurred when I was present in my residence. I also knew deceased Robi Jajwar, who was the brother of accused. On the next day morning, I witnessed villagers running towards the house of deceased, and accordingly, I went there and witnessed the sisters of deceased crying. Police personnel were present in the house of the accused, but I did not witness the accused in the said house. I witnessed cut injuries over the neck as well as other parts of the body of the deceased Robi Jajwar while his dead body was kept at the police station. Police held inquest over the dead body by Exhibit 1, wherein Exhibit 1 is my signature. In cross, I do not know anything about the incident. It is not a fact that I have deposed falsely in the court today. Page 10, PW2. I know the informant Jarobian Jajwar, who is at least almost same, my lord. It's a repeated version of PW1, who is already dead. Accused Abhihud Jajwar is from my village. I also knew this is Robi Jajwar, who was the brother of deceased. I have forgotten the date of incident. Incident occurred in the night hour. The mother of the accused telephoned me and requested me to come to her house as accused had done something, and accordingly I visited the house of accused and witnessed the dead body of Rabi Jajwar lying on the ground with injuries over his neck and various parts of his body, and blood was oozing out of the wounds. Police arrived at the house of accused and held inquest over the dead body in my presence by Exhibit 1, wherein Exhibit 1-2 is my signature. In cross, I do not know anything about the incident. It is not a fact that I have deposed falsely in the court today. PW 3, page 12. I know absentee accused Abhihud Jajwar. This is Rabi Jajwar as well as the informant Jarobian Jajwar, who is presently placed. Incident occurred about 7-8 months back on the relevant day around 10-11 p.m. The incident took place. The house of the informant Jarobian Jajwar, presently dead, as well as his deceased brother Rabi Jajwar are located near my residence. On the relevant day, I heard hue and cry coming from house of Rabi Jajwar. Family members of Rabi Jajwar arrived at my house and informed me about the incident. Accordingly, on receipt of information as aforesaid, I visited the house of Rabi Jajwar and witnessed about accused Abhihud Jajwar shouting in pain, lying in the courtyard of the house of Rabi Jajwar with injuries over his neck. After some time, police arrived at the house of Rabi Jajwar and took the accused Abhihud Jajwar to the hospital for medical treatment. When police broken open the door of room of Rabi Jajwar, I witnessed Rabi Jajwar used to reside alone in his house. Prior to 2 days of occurrence, accused also stays at the house of Rabi Jajwar. Police says two modern wooden pira from the house of Rabi Jajwar by seizure list exhibit 2, wherein exhibit 2, 1 is my signature, as well as a DAO, white seizure list exhibit 3, wherein exhibit 3(1) in my signature. Material exhibit 1 are the said two wooden piras, wherein material exhibit 2 is the said DAO. In cross-examination, accused Abhihud Jajwar was shouting in pain, lying in the courtyard of the house of deceased Rabi Jajwar. I witnessed cut injury over the neck of accused Abhihud Jajwar. Deceased Rabi Jajwar was in the habit of consuming liquor. I do not know how the accused as well as deceased as well as the accused sustained injuries over their bodies. I did not read over the contents of the seizure list, exhibit 2 and 3. Next one is
Yes,
may I read the next one, my lord?
PW,
PW 4, page 40.
okay.
I know absentee accused Abhihud Jajwar, deceased Rabi Jajwar, as well as informant Dorobian Jajwar, who is presently dead. Incident occurred about 7-8 months back. On the relevant day, around 10-11 p.m., the incident took place. At the time, I was present in my house. The house of the informant Dorobian Jajwar, presently dead, as well as his deceased brother Rabi Jajwar, are located near my residence. On the relevant day, Dorobian Jajwar dead, who was the informant of the case, arrived at my house and divulged that there was hue and cry in the house of his brother Rabi Jajwar and requested me to come to the house of Rabi Jajwar. Accordingly, I, along with Rabi Jajwar, PW3, went to the house of Rabi Jajwar, being accompanied by Dorobian Jajwar, and witnessed accused Abhihud Jajwar shouting in pain, lying in the country yard of the house of Ravi Jajwar with injuries over his neck. Sri Ravi Sathawa PW3 informed police about the incident. After some time, police arrived at the house of Ravi Jajwar and took the accused Abhibud Jajwar to the hospital for medical treatment. I also accompanied the accused Abhibud Jajwar to Jorhat Medical College and Hospital,
PW4.
PW4, page 14 and 15. When police broke open the door of the room of Ravi Jajwar, I witnessed Ravi Jajwar lying dead in the room of his residence. Ravi Jajwar used to reside alone in his house. Prior to 2 days of occurrence, accused also stayed at the house of Ravi Jajwar. Police says a dove from the house of Ravi Jajwar deceased by seizure list exhibit 3, wherein exhibit 3(2) is my signature. Material exhibit 2 is the said dove. I did not witness who caused injuries over the bodies of deceased Ravi Jajwar as well as accused Abhibud Jajwar. In cross-examination, accused Abhibud Jajwar was shouting in pain, lying in the country yard of the house of the deceased Ravi Jajwar. I witnessed cut injury over the neck of the accused Abhibud Jajwar. Deceased Ravi Jajwar was in the habit of consuming liquor. I do not know how the deceased as well as accused sustained injuries over their bodies. I did not read over the contents of the seizure list exhibit 3.
Yes.
Page 16, next one is PW5. He is a related brother. I know the accused person, Sri Abhibud Jajwar, who is my neighbor. I also know the informant Jarobian Jajwar, who is dead. The informant was the brother of the accused. This is Ravi Jajwar, was the related brother of the accused in the year 2018. The incident occurred. On the next day of incident around 5 a.m., witnessing people at the house of deceased, I went there and interested the dead body of Ravi Jajwar lying inside the room of his house. I also come to know from the villagers that the accused Abhibud Jajwar was taken to the hospital for medical treatment. I do not know anything about the incident. I was present when police says 2 wooden piras and 1 gamusa from the house of deceased Ravi Jajwar. White seizure list exhibit 2, wherein exhibit 2(2) is my signature. Material exhibit 1 are the said 2 wooden piras. In cross, I do not have any personal knowledge about the incident. I did not read over the contents of the seizure list exhibit 2. I put my signature on the seizure list as police asked me to do so, and it was blank and nothing was written there. It is not a fact that I have deposed falsely in the court today. Page 18, PW 6.
Yes.
I know the accused person, Sri Abhihud Jajwar, who is my neighbor. I also know the informant Zarobian Jajwar, who is dead. The informant was the brother of the accused. This is Rabi Jajwar was the related brother of the accused. In the year 2018, the incident occurred. On the date of incident, the accused came to the house of deceased Rabi Jajwar and stayed there. Hearing shouts of neighboring people, I came out of my house and saw the accused lying with the blood injuries in the courtyard of the house of Rabi Jajwar. At that time, I saw that the door of the house of Rabi Jajwar was closed. In the meantime, police arrived at the house of deceased, and after opening the door of the house, we found Rabi Jajwar lying dead inside his house. I noticed cut injuries on the right hand, right shoulder, and on the, it should be neck, on the neck of deceased Rabi Jajwar. None was present in the house of deceased Rabi Jajwar except the accused Abhihud Jajwar on the relevant day. I was present when police says to Udan Piras and one Gamusa from the house of deceased Rabi Jajwar, white Seizure List Exhibit 2, wherein I put my thumb impression. In cross, I cannot say if any third person had come to the house of deceased Rabi Jajwar on the relevant day of incident. Police did not read over the contents of the seizure list before I put my thumb impression over it. It is not a fact that I have deposed falsely in the court today. Next one is page 20, PW 7. She is the mother of accused, my lord. Accused is Abhihud Jajwar is my accused Sri Abhihud Jajwar is my son. This is Rabi Jajwar was the son of my brother-in-law. Informant Zarobian Jajwar is already dead. The occurrence took place in the month of August 2018 during night hours. On the day of occurrence, while I was sleeping at my house, when the informant Zarobian Jajwar and Rohit Tati went to my house and waked up from our sleep. Accordingly, I, along with my daughter-in-law, Srimati Sandhya Jajwar, went along with them to the house of deceased Rabi Jajwar. There, at the homestead of the deceased, I saw accused with cut injury in his neck. In the meanwhile, accused was taken to the hospital in an ambulance because of injuries sustained by him. As erstwhile Zarobian Jajwar over telephone called his sister Pranita Topna. At that time, deceased Rabi Jajwar was inside the house. So I could see him lying through the gap of the door inside the room. As there was rain, I went to the house of Zarobian Jajwar, now deceased. On day of prior to the incident, as well as on the day of the incident, I saw my accused son with the deceased Rabi Jajwar. In cross, I do not know how Rabi Jajwar died or who was responsible for his death. Page 22, next one is PW 8. Accused Sri Abhihud Jajwar is my brother-in-law. I know the informant Zarobian Jajwar, who is dead now. The incident occurred in the month of August 2018 during night hours. on the date of occurrence while I was sleeping at my house along with my mother-in-law, Srimati Elisara Jajwar, PW7. Then the informant Jarobian Jajwar and Rohit Tati raised shouts from outside, and hearing the same, we wake up from our sleep and went out of the house. Then I, along with my mother-in-law, Srimati Elisara Jajwar, PW7, went to the place of occurrence, which is the house of the deceased Ravi Jajwar. When we reached there, I saw the gathering. I saw accused Abhiho Jajwar at the homestead of the deceased, and he was shouting by calling Ma, Ma. But out of fear, I was standing at some distance away, but I could see cut injury in his neck from where blood was oozing out. On arrival of place, I saw the dead body of Ravi Jajwar from a distance. As far I know, accused and deceased had good relation. In crossed, I do not know how Ravi Jajwar had died. Page 24, PW9. I know the accused Sri Ravi Abhiho Jajwar, who is my related parental uncle. This is Ravi Jajwar was also my parental uncle, being the younger brother of my late father Jarobian Jajwar. On 19/8/2018, around 11 p.m., the incident took place. At the time of incident, I was unmarried and hence residing in the house of my late father Jarobian Jajwar. At the time of incident, I was sleeping in the house. I heard shouts of deceased Ravi Jajwar, and thereafter I asked my father to go to the house of Ravi Jajwar. But as he feared that something had happened in the house of Ravi Jajwar, hence he informed the neighbors about the incident. Thereafter, I, along with my father, went to the house of Ravi Jajwar. I noticed gathering of many people there. I went inside the house and noticed that the dead body of Ravi Jajwar lying in the room with cut injuries over his neck, lying in a pool of blood, and his right hand was also severed. Seeing the incident out of fear, I returned back home. I also noticed the accused Abhiho Jajwar cut injuries over his body lying in the country yard of the house of Ravi Jajwar. Many people took him to the hospital for medical treatment. In cross, I went to the place of occurrence after about 1.5 and 2 hours. I do not know who had caused injuries over deceased Ravi Jajwar as well as accused Abhiho Jajwar. I also cannot say if any third person has committed the aforesaid incident. It is not a fact that I have deposed falsely in the court today. PW 10, page 26. He is the doctor, my lord, who has conducted the postmortem, my lord.
Yes.
Injuries part is mentioned as page 27, my lord. There are 6 injuries over the disease, my lord. Page 28 is the opinion. In my opinion, death of disease was due to hemorrhagic shock as a result of injuries sustained over body as described. All the injuries were antemortem and caused by sharp cutting heavy weapon and were homicidal in nature. Approximate time since death 8 to 16 hours. Exhibit 4 is my postmortem prepared by me. Exhibit 4.1 is my signature thereon. Exhibit 4.2 is the signature of Sri K.C. Das, Professor and HOD, Department of Forensic Medicine, ZMCH, Police and Police Surgeon, Jorhat, Assam. And no cross has been reported, my lord. PW 11 is the circle officer, my lord, who has inquested the body. On page 30, on
Yes.
28/2018, I was posted as Titagar as circle officer. On that day, as per request of Barahula Police in connection with Barahula PS case number 67/18, I went to the place of occurrence, which is a Katsa Trats house. The door of the house was found closed. I found blood marks at the homestay of the house. I also noticed marks of blood stain on the door and walls of the house. On entering inside the house in the front room, one dead body of Ravi Jajuar, age 40 years, male, was lying in the pool of blood. I found deep cut injuries on the head, neck, and shoulder of the dead body. I could notice that on the previous night before the incident, the deceased had male. 2 numbers of pira and 1 blood-stained gamusa were seized in presence of witnesses, namely Sri Zarobian Jajuar, 2 Sri Zirimiya Tapno, and 3 Sri Samuel Tapno. Exhibit 1 is the inquest report. Exhibit 1.3 is my signature. In cross, the door of the house was not locked or bolted. Simply, it was tied by some rope-like substance. So one could easily enter into the house. Page 32, PW 12. I know the accused Sri Abhiyut Jajuar, who is present in the court today. On 28/2018, I was serving as Barahula PS. On that day, Sri Zarobian Jajuar lodged Ejahar before police. Accordingly, the officer in charge Barahula PS Sri Dibba Jyoti Fukan, upon receipt of Ejahar, registered the same white Barahula PS case number 67/18 under section 302 of IPC. The officer in charge Barahula PS himself took up investigation of the case. I accompanied the officer in charge Barahula PS to the place of occurrence and witnessed the dead body of Ravi Jajuar lying in his house. There was a dove near the dead body. The dead body was lying in the pool of blood. I witnessed 1 cut mark over the neck of Ravi Jajuar. I did not investigate the case. In cross, the room of Ravi Jajuar was locked from outside. I also witnessed the accused Sri Abhiyut Jajuar lying in the country yard of the house of Ravi Jajuar. We took the accused to the hospital for medical treatment. At that time, the accused was not in a position to speak and his health condition was serious. Next one is PW 13, page 34. On 31/10/2018, I was officer in charge of Barhola PS. On that day, I received the case of Barhola PS case number 67/18 from SI Sri Devojyoti Fukan, erstwhile IO of this case. Having received the case diary, I have gone through the same and found that investigation has already been completed. Having gone through the case diary, I found that a case under section 302 of IPC is made out against the accused Sri Abhiyut Jajuar. Then I have submitted charge sheet against the accused under section 302 of IPC by CS number 52/18 dated 31/10/2018. Exhibit 5 is the charge sheet, wherein Exhibit 5.1 is my signature. No cross is done, my lord. PW 14, page 36. On 28/18, I was serving serving as officer in charge, Barhola PS, on the day of informant. The Zarobian Jaguar came to the police station and lodged Ezahar before police, which was registered as Barahola PS case number 67/18 under section 302 of IPC. Exhibit 5 is the Ezahar, 5(1) is my endorsement with signature. Myself took up investigation of the case. On 19/8/2018, I received telephonic information from VDP personnel that at Sereli Guhaigaon, some unknown person had assaulted one person who has been lying on the ground in the unconscious state, and they have rang up 108 ambulance to shift the injured to the hospital for medical treatment. Accordingly, on receipt of information of aforesaid one ZD entry number 281 dated 19/8/18 was entered in ZD entry register of Barahola PS. Then I immediately went to the place of occurrence, that is the Sereli Guhaigaon, and in the house compound of Sri Ravi Jajwar, Abhiho Jajwar was lying unconscious with cut injuries in his neck in a pool of blood. In the meantime, 108 ambulance arrived at the place of occurrence, and thereafter Abhiho Jajwar was shifted to the hospital for treatment at Titagarh Hospital. When I entered in the house of Ravi Jajwar, I witnessed Ravi Jajwar lying dead in a pool of blood with cut injuries in his neck. Thereafter, I have reported the matter to the SP Jorhat. I also sent requisition to the magistrate for holding inquest over the dead body, but the magistrate told me that he will come in the morning. Then I have made arrangement for guarding the dead body with the help of PDP personnel, nearby people and police staff. On 28/18, the informant Zarobian Jaguar lost the Ezahar with the police station. The informant is the brother of the deceased Ravi Jajwar. Thereafter, I recorded his statement at the police station. On 28/18 in the morning, learned executive magistrate arrived at the house of deceased Ravi Jajwar and held inquest over the dead body in my presence and in presence of local people. I recorded statement of the witnesses who put their respective signatures in the inquest report. After inquest, I have sent to the dead body to Jorhat Medical College and Hospital for postmortem examination. I also prepared sketches of the place of occurrence, which indexed by the exhibit 6 and 6(1) is my signature. I also recorded statement of other witnesses who were acquainted with the facts and circumstances of the case. I also says 2 wooden piras of size 16 inch in length and 11 inch in breadth, and another of size 15 inch in length and 11 inch in breadth. 1 gamusa stained with blood in presence of witnesses by Caesar list. Exhibit 2 and exhibit 2-3 is my signature. I also said 1 torchlight of size 7 with blood stain, 1 copy dowel with wooden handle, which measured about 16 inch in length with the wooden handle, which was lying at the place of occurrence that is near the body of Ravi Jajwar. White Caesar list exhibit 3 and exhibit 3-3 is my signature. I have witnessed the says articles in the court today. Material exhibit 1 are the says articles, that is 2 wooden piras and 1 gamusa with blood stain, and material exhibit 2 is the copy dowel, but I have not seen the torch light which I was said white Caesar list exhibit 3. Thereafter, I have examined 13 witnesses at the place of occurrence. The says articles were sent to the court. Then I visited Jorhat Medical College and Hospital, where the accused Abhiho Jajwar was under treatment on 18/9/2018. After discharge from the hospital, the accused Abhiho Jajwar appeared before me at the police station. I recorded statement of the accused and thereafter arrest him and forwarded him to the court. On 23rd/10/2018, as I received transfer order on promotion and then I handed over the case diary to my successor, Sri Satyajit Bora, officer in charge, Barhola PS. Later on, Sri Satyajit Bora, officer in charge, Barhola PS, completed remaining part of investigation and submitted charge sheet against the accused to stand trial under section 302 IPC, white CS number 52/18 dated 31/10/18. Exhibit 7 is the charge sheet and Exhibit 7(1) is the signature of Sri Satyajit Bora, officer in charge, Barhola PS, which I know. In cross-examination, that is on behalf of the accused, the name of the scribe of the Ajahar is reflected in the Ajahar, but his name is not legible. I have not recorded his statement. On suspicion, the informant has lodged Ajahar with the police, which has been specifically mentioned in the Ajahar itself. The accused Abiud Jajwar was sent to the Jorhat Medical College and Hospital on police requisition, but I cannot say whether the medical documents of the accused were submitted by my successor or not. I have not sent the said articles for forensic examination. During my part of investigation in connection with the case, I have not found any eyewitnesses to the occurrence. The accused during his statement did not confess before me about the incident. When I reached the place of occurrence, I found the room of Ravi Jajwar locked from inside. It is not a fact that on suspicion we have made Abiud Jajwar as accused in the instant case. Next one is court witness, my lord, page 40. He is the attending doctor, my lord, who has made treatment available to the accused, my lord. On 28/18, I was posted in the same capacity of Jorhat Medical College Hospital. On the day at around 3:05 a.m. in the morning, I examined Sri Abiud Jajwar, aged 37 years, care of Anus Jajwar, on being produced before me by his cousin Sri Gajen Rajkwa. On examination, I found the following injuries over his body. One, cut injury over interior part of neck exposing the entrails and cryocytes cartilage. The nature of injury was previous and caused by a sharp weapon. Number two, we repaired the wound in layers and tracheostomy was done on the same day, that is 28/18. I have not mentioned the dimension of the injury in my part. The patient was admitted on 28/18 and he was discharged on 17/9/18. I have advised for CT scan for the neck, but it was not done. Court Exhibit 1 is my report and Exhibit 1(1) is my signature. Cross-examination, the surgery done upon the injury was life-saving. Had it not been done, the patient would have been succumbed to the same. Next one is 313 statement of the accused, my lord, page 42 onwards. In question number 2, my lord, regarding injuries, he has admitted that yes, I sustained injury over my neck and I gained sense at ICU of Jorhat Medical College Hospital. Next question is, my lord, 3. Answer is relevant, my lord. He gave some explanation to the injury, my lord. On that day, I come to the house of Ravi and we dine together. And as it becomes too late to return home, and then Ravi asked me to stay with him. And then I slept in one of the room of Ravi's house. At night, Ravi went outside feeling warm, and then someone assaulted me and I become unconscious. Later on at hospital, I came to know that Ravi is no more. So far as his involvement is questioned, question 14, my lord, he stated, I am innocent, my lord. And he did not deduce any evidence on his part. Now, my lord, in the judgment part, my lord, court has solely relied on the last scene theory as the deceased and the accused were spent night together on the date of occurrence, my lord.
From 313 itself, it is
Yes,
clear
clear, my lord.
that accused was there
Yes, my lord.
with
Both,
a disease. Disease used to live alone,
my lord. Usually he used to live alone.
but
2 days back, he
your
has-
mother and your sister-in-law also said that
you-
for that
he is
night
there.
you stayed there.
Yes.
Then you said you dined together.
Yes.
So dinner you had taken. Then thereafter at about midnight,
Mm.
this hue and cry.
Yes.
And it seems PW7, PW8,
Yes.
they arrived at the place of occurrence earlier to other prosecution witnesses.
Yes, ma'am.
At that time, police was not there perhaps.
No. They have informed the
Uh,
police,
by
thereafter
com-
police came.
by complainant PW1 and some Rohit informed them, 7 and
Yes.
8, mother and sister-in-law.
Sister-in-law.
At that time, mother saw it through the gap or somebody
That is sister-in-law's evidence, PW7.
PW7.
She said so, my lord.
Just next. PW.
Page 22, last page, maybe.
Hmm.
It's
Sandhya
Sandhya
Jajwal,
Jajwal.
Please, PW8, page 22.
They said simply that your body is lying in this body was lying inside the room.
Yes, madam. As the door was closed, they tried to saw through the hole of the
Whole-
door.
Somebody said
Yes,
out of them.
yes. ma'am.
PW7 said mother.
7 says,
Mother.
mother,
I could see him lying through the gap
gap,
of door inside the room. So they were there.
yes,
At that point of time, did they say that police was there already?
yes.
Or
No, Lordship,
No,
I was
he did not.
standing.
then
at some
thereafter,
distance, Police arrived.
no, thereafter PW3, PW4 and PW6. They went there at the place of occurrence. And they saw the accused shouting in pain in the courtyard
Yes.
and
Well,
This is
the disease
inside the-
inside the house or room. Then police arrived. Police broke open the door,
Yes,
according to them, except the IO.
I,
Except the IO.
and that's
Except-
interesting
Except the
officer.
IO. But the person accompanying the IO, he said that it was tied by a rope from outside.
for circle officer.
Circle officer
Simple-
only says that
It was
as she,
simply, it
she
was
has come next
tied
day,
by
my
some-
lord.
Huh?
She has come next day, not on the day of occurrence, my lord.
no.
So,
One more. One more. Police.
yes, my lord, that is last one. I read.
Uh, This man, PW12. Officer in charge was the IO,
Yes,
but PW12 was another officer,
yes, my lord.
the Kazan outpost. He said, I accompanied the IO. Somebody said it was tied by a rope.
That
Who
is
said?
Lordship,
This is PW 11.
PW 11, Lordship, circle officer.
PW 11. Let us
Page
see
31.
30,
31.
but let us see that IO.
PW 13.
Mhm.
No, not 13, sorry. 14.
Initially, it was investigated by 14 minor. But they are the accompanying officers, others.
Only he said that room was locked from inside. But
But
others,
other PWs, my lord, they have
who
said,
arrived earlier
they have said that he was in front of country yard, my lord.
and the room
Room
was,
This was inside the room. It was closed.
and it was closed.
Closed, my lord.
So he is, that is one discrepancy
Yes, ma'am.
of IO. IO said it was
Closed from inside.
inside, but
But-
all other witnesses, at least PW 7, PW 8, PW 3, 4, and 6. 3, 4, and 6. They arrived before police
Yes, ma'am.
and they said it was locked or closed from outside,
But
not from
that-
inside.
Yes.
That was. And thereafter, PW 1, PW 2, and PW 5 arrived. They arrived after police. PW 1, 2, and 5. By that time, accused was taken
To the
through
hospital.
108 ambulance to hospital. So, PW 7, PW 8, first in point of time,
Yes.
informed by the informant who died already, and one Rohit Tati. Rohit Tati and Jorabi and Jajwar, they came, wake up PW 7 and PW 8, all went there and found accused in the courtyard with injuries, shouting.
Yes.
And door was closed from outside.
Hmm.
PW 8, mother of the
Yes.
accused,
Accused.
saw through the gap
Gap of the door.
that disease was there inside the house or room.
Yes.
Thereafter, PW 3, 4, and 6, they came to the place of occurrence, and thereafter police came. Police they according to them broke open.
Yes.
According to them broke open. PW, let us see PW 3. PW page 15. 14, PW 4, let us see PW 4. PW 3 also. Page 13, when police broke open the door. Page 13, first line.
First line.
PW 4, third line, page 15. Police broke open the door. Right? PW 4. And again, PW, let us see PW 6. At that time, I saw the door of the house of Robi Jajwar was closed. In the meanwhile, police arrived at the house of the accused, and after opening the door of the house, we found the Robi Jajwar lying dead inside the house. So PW 3, 4, and 6.
Yes.
They said door was broke open or open, whatever. Except PW 14 or IO, everybody says,
The door was closed.
and the witness before them. And PW 7 is the mother of the accused.
Yes.
Cannot be disbelieved,
Not
right? And they are closed, their houses are closed.
closed.
And 313 says I was there, I dined with
Okay.
him. By the time, it was quite late in night. I choose not to go, and Disease asked him to stay. Meaning thereby it is slightly more dine quite late,
Mm.
quite late in night, not proper time to go back home, requested by, that is the accused version. Thereafter, PW 1, 2, and 5, they arrived at the place of occurrence. And they have testified about the presence of injuries of the deceased. But PW 3, 4, and 6, they said about the accused as well as the deceased.
Smooth.
These are the situation. And the accused was lying injured
Yes.
outside the house. And he slept inside the house.
Okay.
Door is
Close.
closed from outside. Disease lying
Side.
inside. So these are the situation. What the prosecution is required to prove. Yes, the DAO should have been sent for
FSL.
FSM.
That
That was not done. That is a defect. Whether that would accrue any benefit to the accused. This is one. Secondly, last seen together appears to be applicable. That time gap, I think trial court has applied the theory.
Yes, that is the
And
only.
time gap is not
Very
always that dining together late at night, in the midnight, hue and cry.
Yes.
Gap is not that long.
Yes.
Now question is whether there is, and they slept together in a room, separate room,
Separate,
inside the same house,
same house, house is same.
same house. So in such situation, how you have received the injuries, somebody injured him,
Mm.
then felt unconscious or what? That appears to be not true because everybody saw you shouting.
But the injury part is there.
313, let us see 313.
Yes. Question number 6.
Let us see 313. Some explanation was there.
Yes, page 43, my lord.
Uh,
Injury
something
part
he has
did
admitted,
not-
something he has admitted, then
Yes.
what he said?
Injury part on his part, that is admitted in question number 3. my lord.
Question number 3.
3, page 43.
Then I slept in one of the room of Robi's house. Slept. Then at night, Robi went outside feeling warm. I don't know how his body
After
got
getting
inside the
injured,
house,
after getting injured.
bolted from outside. And next part, I became unconscious. This part, then whether it is your mother, your sister-in-law, let us see your sister-in-law.
Even
And mother,
sister-in-law
PW7.
says that he
PW7.
is calling his mother also, mom.
PW7, let us see your mother. Accused Obihud Jajwari is my son. I saw accused, criminal accusers taken. Your sister-in-law perhaps.
Yes, ma'am.
I saw accused, you're shouting by calling mama, right?
Yes.
Now come to PW6. He saw hearing shouts, okay, he has not specifically said.
That time I saw that the door of the house of Rabi was closed. In the meantime, police arrived at the house.
PW 4. Witness accused Obihud Jarwar shouting in pain. lying in the courtyard. PW4.
Yes.
Oh, sorry, PW3. I'm sorry.
Four also, my lord.
Four
Page
also,
40,
Lord.
Ah,
last
PW4, shouting in
Stop.
pain.
Pain, lying in the
So
courtyard.
this
Injury-
explanation of accused, if turns out to be false,
that he
that's
was
lying unconscious.
instantly.
Your mother was saying,
Yes.
how can
Wife,
the mother, oh sorry, your sister-in-law, who was supposed to protect you,
Yes.
then these independent witnesses, they saw you, three saw you shouting in pain. So
Yes.
your becoming unconscious is quite
Late.
disbelievable.
after the
And if
incident.
this is false, then that becomes an additional link.
Implication.
Then that becomes, because these are your mother or sister-in-law,
They have
Ah.
deposed in that manner.
so it is your also duty how you sustained. It is not always, which is
Prosecution.
not possible.
Yes. As no one.
For
unless these two
prosecution,
persons
If only
are
there are
already
two
there.
persons inside the house and all theories are not really applicable.
Yes, yes, this depend upon circumstances.
Dependent on fairness of
Facts,
circumstances.
circumstances.
There were 2 rooms. Perhaps it is, let us see the sketch map.
Sketch is not properly drawn, I suppose.
Uh-huh.
Not properly drawn.
How many rooms?
Page 91 is the sketch. 2 rooms it is shown, my lord.
2 rooms.
Yeah.
So 2 rooms, 1 room, accused sleeping,
But
the other room,
where the,
apparently this is sleeping.
yes, but where that accused person was lying, that contiguous portion, it is not marked, my lord.
But everybody is saying
Yes,
sketch map is just for, but oral evidence, courtyard,
yes, yes.
what is age? What is age? Hey, some cows. EFZH.
H I don't find
Let us see.
in this translated portion, I don't see.
It is translated. Something is age.
That might be the place where
Original
accused
textbook.
may lie.
Exhibit
6 months.
6. In the motor, that's right. Nothing in. এটা ইসরো লিখা নেই কিন্তু ইসরা মার্ক করা আছে। ইসরো লিখা নেই আছে কিন্তু লিখা নেই। Nothing is there as regards age. But courtyard of the house. So these circumstances, then you owed an explanation, and you provided an explanation which turns out to be not correct. Then you owed an explanation how the disease sustained the injuries also,
Yes, that part.
and that
not
part was not
explained.
there.
Neither the
And your
prosecution-
explanation about your injury, somebody
Who is that somebody?
who
It
is that
also-
somebody is not
there
there.
is no
The gap is
nomenclature.
too small. Merely by that explanation, I don't think that is sufficient. There appears to be.
Yes, that may be he is getting a bit clever and try to get himself rid of all these things. my-
Because
He was
it is
confused.
not that diseased
But-
one injury. accused one injury, right?
Who has caused
Or
injury
Then,
to-
then it could have been,
From a physical out, my lord.
and even if we assume exception 4, then one cannot take unfair advantage.
Yes,
He give 1, suppose. You gave 6.
that is the injury.
Quite
That is their lordship.
unfair.
But
So-
one thing that, my lord, in my humble
Much
submission.
more accept the defect, sending the,
FSL,
Not sending the FSL.
that whether that will
Come-
accrue any benefit to the accused.
Exact-
In a case of circumstantial evidence that requires, but that is a defect.
Defect.
Leaving aside that,
PM is there where everything is there about the.
That injury part is there, my lord, that
But
cannot be.
here
denied.
is a case, it appears that you owed an explanation.
But that explanation has
And
not come in.
You provided one, but that explanation was quite contrary to your mother
Yes,
or
yes,
your
yes,
sister-in-law,
my
and
lord.
plus 2 independent witnesses. Your side shouting, Mama, you could have named the assailant also.
Yes,
If you're shouting Mama or pain,
that much conscious if he has.
he
can
had,
At
He-
least
that
tell
is a-
someone
yes,
present there that that person
I
so and so
came
has
sense
caused
in
injuries
ICU,
to
but
me.
he was conscious in there only.
they were said shouting in pain.
Shouting in pain.
And sister-in-law will not say unreasonable that you were shouting
Shouting
Mama.
mama.
Yes, that's issue.
Yes, yes, sir.
Can it be day after, my lord? If I have some.
Day after tomorrow, I think we have fixed one, I think,
Yes,
Yeah.
lordship, with already.
some Endeka
Evidence.
case.
No, after that, because I have some personal difficulty.
No issue, we have heard. We have heard. If somebody has proxy. Okay. Otherwise,
Some person had occurred date, my lord, so due to that, I have to attend some ceremony.
it's okay, we have heard. Huh? We keep it for further hearing, but we'll decide after the admission or order.
So far as this chain is completion of chain because of not sending the.
No, prosecution has been able to
Beyond
make out a
the-
privacy case owing an explanation from your side.
That is silent.
That is there.
Shifting of burden because which is possible to be proved by the prosecution they have established.
Yes. What is in. their
Something,
hand?
IO cannot be there prior to
Yes.
murder.
Okay.
No, not possible.
Possible.
Had it been their third person,
Yes.
had
that
there been
we
a
are trying
third
to-
person,
Trying to get an explain.
And it is established that the
It's not established.
this is a bachelor,
Suggestions.
he was a bachelor,
He was
Yes,
better.
he was living
Living
alone.
alone in his house.
And you went to your that place, why you
That-
have gone to your place, his place?
As he was alone always.
Yes,
You went there,
Dine together.
which usually not my.
dining together,
That also.
whereas
leads
your house is very nearby.
Very nearby.
Yes. But if there is some.
Dine together.
And
Then
he was
you
conscious
thought
that-
that it was quite late in night.
And he was conscious.
yes.
Was
That
shouting.
is
He
the-
was conscious that he was the.
Okay, but M. Gorman, learned amicus, query for the appellant and MS A. Begum. Additional public prosecutor, learned additional public prosecutor for the respondent state. This is the case tomorrow as part of it. Yes, yes, anybody?
I mean, item number 5, my lord.
5, what happened to Mr. Gogoi, Dr. Gogoi?
One
Out
advocate.
of station or what?
Yes, man. I was
Hmm?
informed. I was informed that he is out of station.
You were for a respondent or what?
Yes, man. For the informant.
Oh, you are for the informant.
Yes.
Offense,
302 IPC, my lord. Was sentenced to life imprisonment.
direct evidence or indirect?
Direct evidence.
I will
Ocular
fix that,
evidences.
Lordship.
Two
Huh?
direct eyewitnesses, my lord.
7 years old.
Okay. Mr. MS A Begum, learned additional public prosecutor for the respondent number 1, State of Assam, and Mr. SH Mahmood,
Yes, sir.
learned amicus curiae for the respondent number 2 are present. So Dr. BN Gogoi, learned amicus curiae for the appellant is found absent today on call. Also, raise the case, comma for inch of justice in view of non-appearance of the learned amicus curiae for the appellant, comma, raise the case for inch of justice Thursday. Do you hear? Thursday.